The European Court of Human Rights is considered one of the most important human rights courts in the world, and Ireland was a founding member of this court. Welcome to the podcast series, The European Court of Human Rights, an Irish Perspective. In this second episode, we explore the question of what was Ireland's contribution and influence on the development of the Convention and the European Court of Human Rights.
I reflected on this question and I thought it's important to put it into the historical context of the time at which the Convention was being thought about, negotiated, drafted and then signed.
Síofra O'Leary, former judge and president of the European Court of Human Rights.
Ireland was probably the only country which hadn't been involved in the Second World War, which hadn't experienced directly the brutality of that war. But of course, Ireland, with its history, which was long and painful, was bringing experience of violation of human rights to the table in a different form.
Just to put this in context, you must remember that Ireland at the time was a relatively new state.
Miss Justice Isolde O'Malley, Judge of the Supreme Court.
The negotiation was going on in the 1940s. Ireland had achieved independence in 1922. We didn't have much of an international profile. We were a member of some technical organisations on the financial, fiscal side of things. We had been asked to join NATO, were invited to join NATO, and refused because the government said they couldn't join in a military alliance with Britain so long as it was occupying part of Ireland. And we really didn't have any other international role. Here was an opportunity for Ireland to play a part in shaping a new Europe after the war and the horrors of the war. And the government got quite enthusiastic about that.
Looking to what they brought to the table, here was a common law jurisdiction like the United Kingdom, but with a very different approach to human rights, because the Constitution had introduced not just a Bill of Rights, but also a strong form of judicial review, which is anathema to the UK system, where parliamentary sovereignty is and was a very strong concept. So we had two common law jurisdictions which played a very important role at the negotiating and drafting stage, but they had very different perspectives from a legal, constitutional and historical point of view in relation to individual rights.
And if we then talk about the drafting of the European Convention of Human Rights, Irish diplomats and the then Minister of Foreign Affairs, Sean MacBride, did play an important role in that.
Mr. Justice Gerard Hogan, Judge of the Supreme Court.
We were among those who pressed the drafting committee to make sure that the family was protected. Article 8 of the Convention, which guarantees respect for the home and family life. And that, I suppose, reflected, traditional Irish Christian, maybe even specifically Catholic values, and reflected Article 41 of our Constitution, which guarantees the family and the autonomy of the family as against the state. And that was an important concern which was shared, I think, not just simply in Ireland, but throughout Western Europe. I mean, it had been one of the features of totalitarianism that, in a sense, the state was all-powerful when it's seen that during the Nazi period. But also, it was part of, if you like, the Soviet ideology that was now dominating Eastern Europe.
MacBride played a very important role in the drafting of the Convention.
Michael O'Boyle, former Registrar of the European Court of Human Rights.
And that he emphasised that there should be a court that had responsibility for supervising the provisions of the Convention, making sure that they were conformed with.
Yes, and it made orders characteristic of a court, and its rulings would be binding as a matter of international law. And MacBride, in particular, was very influential in pushing for the right of individual petition.
The right of the individual to make a complaint, as opposed to another state. In those days, we're back in the 40s and 50s, the individual didn't have any rights to go to the court. It could only bring its case to the Commission. And it was the Commission, after it had examined the issue, that had the possibility of bringing the case to the court. MacBride insisted that Ireland, from the very start, accepted both the right of individual petition before the Commission and the compulsory jurisdiction of the court.
And MacBride was very strong on this particular point. He and others in the Irish delegation could see the value, which is enduring to this day, of Europe being dominated by moral, ethical, legal, and social values rather than might is right. And they saw that the progress at international legal level, which could be achieved by and through the convention, would have been unimaginable before the Second World War, but it had become absolutely vital given the lessons learned from the Second World War.
This whole idea of a state being held responsible for human rights abuses against its own population was quite new, and it had really come to the fore at Nuremberg. There wasn't a precedent for that. So the traditional view was that a state could do whatever it wanted in its own territory and wasn't answerable to anybody else. The convention changed that, and some states weren't entirely happy with that. They didn't know how it could work. But as I say, MacBride and others said, no, it has to be that a person can take their own state to the court. So that wasn't necessarily easy to get acceptance of.
Now, the compromise was that there was what was called an optional protocol. Member states could opt to allow themselves to be sued by their own citizens before the ECHR. And we were the first, along with Sweden, to accept that jurisdiction.
And interestingly, the Irish delegation apparently was of the view, and this was, I think, the advice of the Attorney General at the time, that the state didn't have to worry too much about accepting the jurisdiction of the court because Ireland's constitutional and legal framework was such that Ireland wouldn't have any problems before the European Court of Human Rights, whose jurisdiction the state was accepting. And there was a difference of view on this point between the Department of Foreign Affairs and the Department of Justice, because the justice officials were actually concerned that some provisions of the Offences Against the State Act or the lack of free legal aid in criminal cases would create problems for Ireland under Articles 5 and 6 of the Convention. And at some point, so it came to pass. But Ireland wasn't the only delegation which thought that it wouldn't have any problems because everything was perfect at home. Many of the signatories regarded the Convention as an instrument which would be useful in relation to other states, but not their own.
And the first case before the ECHR was an Irish case, Lawless in Ireland, which I'll come to in a moment. But this was so novel an idea that many member states didn't give that jurisdiction to the European Court.
States have to specifically undertake to permit the Court of Justice to exercise jurisdiction in their cases. And we call that the compulsory jurisdiction of the court. In those days, states had to sign a document which accepted that they could be brought to the court as part of their treaty engagements.
The drafters of the European Convention wanted to make sure that the rights guaranteed could be litigated and ultimately enforced at a practical level. In this respect, they wanted to go further than the drafters of another well-known human rights document, the Universal Declaration of Human Rights, created under the auspices of the United Nations.
But it does have to be said that the Irish delegation, and Sean MacBride in particular, they were visionaries in the sense that they wanted to ensure that the common standards which had been already set out in the Universal Declaration would be given binding legal force, and that there would be an enforcement mechanism to ensure that those rights were respected. Now, nowadays that sounds quite passé, but this was recognition of the right of an individual to bring a state before an international court to allege a violation of their individual human rights by that state on the international stage. And that was truly groundbreaking.
It really only became normalized for all of Western Europe by the late 70s, early 80s. Since the 90s and the reorganization of the European Court of Human Rights on a full-time basis after 1998, every state has to accept the jurisdiction of the European Court. I mean, if you want to be a member, you want to be a contracting state, you've got to accept the right of individual petition. But remember, while we signed up to the optional protocol, which was a big thing, we didn't incorporate the convention into national law. And remember, under Article 29 of the Constitution, an international agreement is not part of our domestic law, save to the extent it's determined by the Oireachtas. And the Oireachtas did not actually get around to doing that until the European Convention of Human Rights Act 2003, itself, if you like, a byproduct of as much of the Good Friday Agreement as anything else.
The European Convention on Human Rights is a remarkable instrument because it allows individuals and the state to essentially identify individual and systemic problems in their own legal system and then remedy them. And the remedying process may be difficult. The declaration on the international stage that a state has violated international law may be very uncomfortable. But if we take a long-term and historical perspective, over 75 years, this has inured to the benefit of thousands of litigants, but also to all European states.
And the first judgment in a case brought by an individual against a state was the Lawless versus Ireland case of 1960.
Yes, ironically, given what we've just been discussing, the fact that Ireland thought it would have no difficulties, Ireland gave rise to the first judgment in an individual application, the Lawless judgment, and the first judgment in an interstate case in which Ireland acted as the applicant state. And we might touch on that a little bit later.
You know, no serious historian of the European Court can begin to tell that story without reference to Lawless.
Lawless had been arrested and interned on suspicion of IRA activities. It was at the time of the IRA border campaign in the late 50s, and a lot of people were being interned. He took a case in the Irish courts because you have to exhaust your remedies. You must go to your national courts before you can go to Strasbourg. And the Irish courts said you are lawfully detained. The state was prepared to release anybody they had interned if they signed an undertaking not to engage in those kind of activities. And ultimately he gave the necessary undertaking. But the case proceeded in Strasbourg anyway. And interestingly, at this stage, Sean McBride was back in practice as a barrister, and he acted for Lawless in Strasbourg.
Lawless is a very interesting case because, of course, given that it was the first case, it raised a lot of new legal questions for the applicant, for the Commission of Human Rights, because at that time there was a European Commission of Human Rights which dealt with the case before it was referred to the court. It was a necessary preliminary step. And then there was the court itself. So the Lawless case, the court had to put flesh on the procedural bones that were available to it because it had never dealt with a case like this before.
And that was huge news in Ireland. I mean, it was huge news elsewhere as well, but huge news in Ireland, you know, front page headlines for a lot of early 1960s. I mean, there was a lot of excitement in the ECHR too, because this was the first individual petition case coming before the court. The court was consisted at the time of part-time judges. You know, it was really a big, big deal for everybody. So the case proceeded before the European Court. The court held, yes, interment to that trial is in theory a breach of Article 5 of the Convention, which guarantees, if you like, personal liberty, save detentions authorised by law. There isn't an exception for internment. But when Ireland had reintroduced the internment provisions of the Offence Against the State Act in the late 50s, it had entered what's known as a derogation, as was permitted at the time under the Convention. In other words, you can derogate from the Convention in times of war or in strange times or in times of kind of emergency. And we had done that by reason of the security threat posed by the IRA border campaign. And the ECHR said this, therefore, is not a breach of the Convention because, okay, it's a breach of Article 5, ordinarily to be interned, but there would have been a breach of the Convention but for the fact that we had successfully and validly derogated under Article 15 because of, like, the emergency times at the time by reason of the IRA campaign.
And that argument essentially is an argument in favour of what's called a margin of discretion, a margin of appreciation. You could otherwise call it a margin of maneuver or a margin of discretion. And you'll see states arguing that position since Lawless from then on.
It is, of course, a case of immense significance. I'll tell you a small anecdote. I was in Belfast in a stationery office as a 12-year-old, and a barrister came into the office looking for a copy of the Lawless judgment. And I'd never heard of the Lawless judgment, needless to say. And the man in the stationery office gave him 2 huge volumes that he could barely carry out of the shop. And so the image stuck in my mind of this barrister leaving the room carrying this case. I thought, what on earth is this about? In the north of Ireland, emergency powers were much more of an issue than they were in the south of Ireland. So the Northern Irish were particularly enthusiastic to see what the Court of Human Rights had said about the possibility of scrutinizing emergency powers. So in Lawless, the issue was Ireland had declared a derogation from the convention. If you like, that's a suspension of the guarantees. Now, in a human rights treaty, if you suspend the guarantees, then what is the point of the treaty? So the question that the court was faced with was there any possibility to scrutinize the legal validity of that derogation? Now, the convention makes it quite clear that you can derogate in limited circumstances. There has to be a public emergency, but an emergency which threatens the life of the nation. That's a very specific term. So it conveys an intensity or a situation of public order of such magnitude that it's much greater than a threat to public order. And secondly, that the derogation be proportionate, that in the convention terms, that it be strictly required by the exigencies of the situation. So both of these terms were interpreted in the famous Lawless case, of huge importance for human rights treaties.
The court was very meticulous in this case. If you look at the database, you'll see that there were actually 3 separate rulings. 2 were on procedural issues, and 1 is on the merits of the case, on the substance of the legal questions before the court. And on the substance of the legal questions before the court, you have a very delicate issue. This is a state seeking to rely on the emergency provisions derogation, arguing that there was a situation which threatened the life of the nation. And the court had to establish, well, when can this emergency powers derogation apply, in what circumstances? And had the state justified the detention of Mr. Lawless without trial with reference to the requirements, the strict requirements of an emergency situation? And as we know, the court found no violation in relation to Mr. Lawless's rights. But in finding no violation, it set out what states had to prove when they sought to rely on Article 15 of the Convention. And that has remained relevant and is cited to this day. During the time I was at the court, we had to deal with France's reliance on Article 15 during a sustained period of terrorist attacks in France from 2015 onwards, Turkey's reliance on the same provision following the attempted coup d'etat in 2016, and then, of course, during the COVID pandemic, many states relied on emergency provisions in relation to measures they took in response to the pandemic. So the Lawless case is cited to this day, and the principles established by the judges in that first case are cited to this day.
And then the first interstate judgment was the 1976 case, Ireland versus the United Kingdom.
The interstate case that we brought against the UK, arising out of the use of the so-called 5 techniques that the British had sanctioned for use against internees in Northern Ireland after internment was introduced in Northern Ireland in August 1971, and Britain had derogated from the internment provisions in the same way that we had in the Lawless case. But Our complaint was not about internment as such, but rather about the techniques that were applied to the people that were interned. Sorry, I should have explained. You can derogate from some things because of emergency and time of strife and so on. But there are certain things you can't derogate from. And one is Article 3 guarantee against torture and human and degrading treatment.
Ireland against UK case was, of course, very politically sensitive at the time. And it posed a lot of legal challenges because this was the first interstate judgment. Irish people will know this case as a case relating to the hooded men, an issue which has been very high profile in Ireland before, during and since the judgment, which was handed down in 1978. It's, I think, well known probably also by your listeners that the European Commission of Human Rights decided that there had been a violation of Article 3 and that the treatment of the hooded men, which essentially amounted to different forms of enhanced interrogation, it constituted torture. The Irish government decided to refer the case to the court, and the court proceeded to look at the Commission's report, but it also indicated that it would take on board any other evidence available to it. And in a split decision, the court found also that there was a violation of Article 3 of the Convention, but it held that the treatment of the hooded men didn't reach the level of severity to qualify it as torture. What was important about the decision, despite what some would regard as a very disappointing output at court level, is that a state, the United Kingdom, and an original signatory of the Convention, which didn't expect to find itself before the court, was found to be in violation of one of the most important provisions of the Convention, Article 3. The court also provided a definition of what constitutes torture and inhumane and degrading treatment. And the judgment showed that the collective enforcement mechanism can and could work. It was a groundbreaking judgment in every respect.
Again, if one looks at this judgment, it's also the type of judgment that is going to be referred to constantly because of its importance and because of the range of issues that it looked at. Not only did it look at questions relating to the existence of a public emergency, whether the measures taken were proportionate, whether they were strictly required by the situation at hand. It also looked at questions of evidence and also the fact-finding that went on by the Commission. Like in the Lawless case, it was left to the Commission of Human Rights to assess the facts. And to do that, they had to travel to hear witnesses in Norway and to deal with a whole host of evidentiary problems that were raised by the British at the time. And so the case is also famous for establishing, if you like, the blueprint for an examination of the facts in a highly controversial and political case such as this one. And for the first time, the court used the expression margin of appreciation. The court has become famous for. When examining these issues, it will attach great weight to the determination of the national authorities. And in so doing, afford the state a margin of appreciation when it comes to assessing the legal validity of what they've done. And so that concept has come to amount to probably the most important interpretational doctrine that was developed by the court in its examination of ordinary cases, that it will afford a certain deference to the national authorities when it's examining an issue.
Now, of course, there was some concern about this downgrading of the finding from torture to inhumane and degrading treatment. And following a lot of research done in the archives when they became publicly accessible, the Irish government decided to introduce a revision request based on the fact that the UK government was alleged not to have made full disclosure of the relevant medical evidence. And at the time of the original judgment, both the Commission and the court were very clear. They recognised that the UK hadn't fully cooperated with the Convention organisms during the course of the proceedings, but it didn't draw any conclusions from that. The court, by a majority in 2018, rejected the revision request. I found myself in the uncomfortable position of being the sole dissenting judge. The judgment was decided 6-1. But what I think it is important to take away from the Ireland against the UK case, even if the revision request didn't succeed, is that in subsequent cases before the UK courts, those courts recognised that what had happened to the hooded men would constitute torture as defined nowadays. And the Court of Human Rights itself, in case law from a judgment called Salmuni onwards, made very clear that modern day standards in relation to how people are treated would regard treatment that had been not considered torture in the past, that would be regarded as torture to this day. Again, fast forwarding to the interstate cases that I dealt with when I was in Strasbourg involving Georgia and Ukraine, Ireland and the UK is cited throughout those judgments because in that case, the court established for the first time how the interstate mechanism was intended to work, what a state had to do when bringing a case. Some of the issues are quite technical legally, so I won't go into them, but they established standards and burdens of proof in interstate cases. And all of these things you will see cited in judgments to this day. But I think you have to understand what is the nature and purpose of an interstate case, because it's different from an individual application. In the Statute of the Council of Europe, which dates from 1949, I'm going to quote from what the statute says. It provides that the organisation was set up to establish a common public order of the free democracies of Europe with the object of safeguarding their common heritage of political traditions, ideals, freedom, and the rule of law. And the interstate case speaks to that objective because it means that a state can introduce an action against another state which it considers is acting in contravention of European public order, which is a very broad notion, but it's well reflected in that statement from the 1949 statute. Interstate cases allow states to seek collective enforcement of rights guaranteed by the Convention, regardless of the nationality of the individuals involved and regardless of whether the state's interests are in play or not. The interstate case is not a forum in which two states are carrying out a political dispute. It's something above that. It's at the level of European public order and the rule of law. And if you fast forward to the interstate cases which were pending before the court when I was a judge and then president, cases brought by Georgia against Russia, brought by Ukraine and the Netherlands against the Russian Federation, in relation to the conflicts in Europe that we still see ongoing today, you see that public order aspect involved. It's not about Ukraine defending its interests. It's about Ukraine and the Netherlands defending the general public interest in having free democracies which are underpinned by the rule of law.
These two cases, the lawless case of 1960 and the 1976 case of Ireland versus the United Kingdom, and Ireland's involvement in the drafting of the Convention, have become cornerstones of Ireland's contribution to the European Court of Human Rights.
The whole notion of contribution to the protection of human rights by Ireland, I would prefer to say it as a contribution by the Irish people to the success of the convention system and by its lawyers. I think in terms of the lawyers like Mary Robinson and Kevin Boyle from Northern Ireland, who was a colleague of mine in Queen's, who had brought such leading cases from Northern Ireland concerning the H-Block crisis, the hunger strikes. Kevin Boyle also brought a case, the famous Dudgeon against the United Kingdom case, which raised the question of homosexuality and its prohibition under UK law. And this was brought before Mary Robinson brought the Norris case, which raised the same issue. And these lawyers were using the tools at their disposal as creative lawyers in the knowledge that they had the possibility not only of getting a remedy for their clients whose rights had been infringed, but also to bring about legal change, which would benefit many others. And it's in that way that I look at the whole question of contribution.
As regards people, and of course, institutions don't work without people, and the success of the convention mechanism is down to the people in the registry and the judges who've served in that court over many decades. The court has been very fortunate over the years to have had many Irish and UK common lawyers working within the registry, and several Irish people have occupied important positions, such as Michael Boyle, he was Deputy Registrar, Anna Austin and Lawrence Early have and serve as the jurisconsult, and John Darcy, he now serves as the Grand Chamber Registrar. What these people bring to the convention system is, first of all, really exquisite knowledge of of the Commission, the court, and how the system has worked for many years, and of the case law, but they also bring the particular skills and insights of common lawyers in terms of drafting and case law coherence, which is absolutely vital when you're talking about a court which is dealing with about 38,000 applications a year, which has issued well over 1 million judgments and decisions in the course of its history. Coherence is difficult to achieve when you have so many judges and so many cases. And these people have been vital in that respect, despite the fact that Ireland and the UK have actually a very low number of cases themselves. It's their broader skills which are absolutely vital. As regards Ireland's contribution, this is a funny one because we can tend to look back and we can tend to say, isn't Ireland great? Look all we brought to the drafting and negotiation of the convention, and then we had the first judgment, and then we had the first interstate case. But in fact, a state's contribution to the convention system is actually measured via the impact cases in which it has been a respondent state are. That means cases in which individuals have alleged that there are individual or systemic deficiencies in the national system. And if you think back to the Irish caseload at previous times when it was heavier than it is now, I'm thinking of cases like Norris on the right to privacy, like Airy on access to court in civil cases, like independent newspapers on juries and quantum of damages and defamation cases, like ABC and Ireland in relation to the need to legislate following the Supreme Court's decision in X, or cases like O'Keefe on historical sex abuse cases in Irish national schools. All of those cases have led to findings of violation of the Convention by Ireland, but the impact is in the social and normative changes which have followed those judgments. And the impact and the most important contribution a state can make is in accepting the judgments of a court, even an international court, and acting on foot of those judgments to respond to the individual and systemic deficiencies that the court has identified. As I said previously, it is uncomfortable, even for some states or in some issues. It's painful to be called out on the international stage. But the truly positive impact of a state is when it actually gets to grip with some of the skeletons in its legal, constitutional and social cupboard. And I think over time, Ireland has done that remarkably well. The Irish courts have gone from a position of treating the convention as a somewhat alien text to integrating it in how they approach constitutional questions. They speak mainly in terms of the constitutional and statute and common law. That's perfectly normal and acceptable, but they understand and integrate the convention when necessary. Of course, one can disagree or agree with different judgments of the Strasbourg Court or indeed of the Irish Superior Courts. But the rule of law is dependent on states acting in good faith. And in general, the Irish state has acted in good faith and been a strong supporter of a rules-based international order, which never before, since the convention was drafted, is that rules-based order more important. Some people will tell us that it's dead and that we shouldn't be nostalgics and cling to it. I tend to be of a different opinion and consider that the peace and prosperity that we've lived for the last 75, 80 years is also down to that rules-based order.
In our next episode, the third and final episode in this first series, we will explore some of these cases when we examine the European Court of Human Rights' impact on Ireland. You have been listening to the European Court of Human Rights, an Irish perspective, a curious broadcast production for the European Court of Human Rights. Original music score by Conor Lenihan, narrated by Rory Lonergan. Thank you to our contributors, Síofra O'Leary, former judge and president of the European Court of Human Rights, Miss Justice Iseult O'Malley, Judge of the Supreme Court, Mr. Justice Gerard Hogan, Judge of the Supreme Court, and Michael O'Boyle, former Registrar of the European Court of Human Rights. Special thanks to the Department of Foreign Affairs and Trade and our editorial team, which includes Mr. Justice Brian Murray of the Supreme Court.